So this is Krystal O'Connor from the Great American Outdoor Show, and I'm here with Mr. Joshua Prince, who is with the Firearm Industry Consulting Group. He's also an attorney here in Pennsylvania, a very pro 2A attorney. Joshua, how are you?
Doing well, Krystal, and yourself?
I am fantastic, and it's actually by chance that I ran into you, and I recognized the name, and I was like, oh, I got to get that guy on air.
We really appreciate it. We love it. We're supporting the Second Amendment here at the Great American Outdoors Show, and we just have so many patriots that are out here today, full force, showing their pride in everything that Pennsylvania is.
It's great to be walking the halls with a couple thousand Pro 2A like-minded people. But to get straight to it, I wanted to talk a little bit about legislation. I talked to the NRA earlier, but they don't have their ILA chapter here, so legally, they can't really cross that line. So I talked to you. My representative, Rick Saccone in Pennsylvania, is looking to expand some of the Castle Doctrine stuff to include disparity of force. Can you talk a little bit about what disparity of force is and why that's important?
Absolutely. One of the issues that we have here in Pennsylvania since the enactment of our new Castle Doctrine / Stand Your Ground Doctrine is that it doesn't address a situation where you have multiple aggressors going after one individual. So right now, as it stands, you can only use lethal force outside of your car and outside of your home if you have the legal right to be where you're at, that the individual poses you a risk of substantial bodily harm or death, and that you have a legal firearm. The issue that's not addressed is what happens when there's multiple aggressors coming after you. Can you use lethal force against 2, 3, 4, 5 individuals who are coming at you who may not have a weapon but still pose that risk of substantial injury or death? And that's really what Representative Saccone wishes to clarify under the law, is that yes, in that disparity of force situation, you can use lethal force. The other issue that disparity of force also addresses is a situation where you may have a young lady who may be only 100, 105 pounds up against a guy who's 250 pounds. Again, under the law, it says that generally speaking, that individual would have to have some sort of weapon and be using against that woman, unless there's certain exceptions for rape and things like that. But just generally, there isn't anything that addresses that situation. So I believe what Representative Saccone wants to do is try and address that situation. Obviously, it becomes difficult as to how to word that legislation so that it covers those types of situations but doesn't go too far.
Fantastic. Thank you so much for that explanation. I know we've covered that in the past on the show, so having an attorney specifically address that topic is great. Now, you also mentioned that there are some things happening in Pennsylvania with regards to mental health. Can you elaborate on that?
Yeah, absolutely. We've had an issue with regards to involuntary commitments, which we refer to as 302s here in Pennsylvania. About a year and a half ago, the Superior Court issued a decision that said that the statutory language that says that a court can grant such relief as it deems appropriate does not include expungement. And that has resulted in individuals not being able to get federal relief from being involuntarily committed. There are a number of issues with Pennsylvania's Mental Health and Procedures Act, as it does not provide any form of due process. To be 302'd, it's simply based off a doctor's signature. You don't have the right to confront witnesses. You don't have a right to submit evidence. You don't even have the right to a neutral arbiter. And some people will say, well, how's that the case? Because you have this doctor who doesn't even know you, who's deciding whether to sign you in. The problem that they don't understand is there are a number of hospitals that make millions of dollars off of involuntary commitments, and there are some hospitals that haven't met someone who didn't need to be involuntarily committed because of the financial stakes that are at play. So we are looking at enacting some new regulations regarding our Mental Health and Procedures Act that would allow for people specifically to get expungement or relief that would relieve both the state and federal disability, so that those individuals can again have their Second Amendment rights. The other thing that's at issue is recently the Sixth Circuit Court of Appeals, a federal appellate court, issued a decision stating that a single isolated occasion where someone is involuntarily committed violates the Second Amendment to prohibit that individual for the remainder of their life from being able to have a firearm. The NRA Civil Rights Defense Fund has actually granted us, our firm, Firearms Industry Consulting Group, several requests for funding to fight the Mental Health and Procedures Act here in Pennsylvania under those same grounds. So this year, we'll actually be filing several federal lawsuits against Pennsylvania's Mental Health and Procedures Act to attempt to eviscerate this disability that should have never existed from the beginning.
Good, good. Can we also talk a little bit about the preemption fight that's happening here in Pennsylvania? Pennsylvania has always had, or at least as long as I can remember, had preemption built in, so local municipalities, counties, etc. can't pass their own gun laws. But we expanded on that recently to say that local municipalities who do pass their own gun ordinances can be punished by being sued by citizens and also groups. Can you talk a little bit about that and what's at stake?
Absolutely, and it's kind of best to start at the beginning. Since 1974, it's actually been a crime, a misdemeanor of the first degree for any municipality to enact any type of regulation regarding firearms or ammunition. Unfortunately, municipalities have thumbed their nose at the General Assembly and said, too bad, because district attorneys aren't prosecuting the municipalities for violating the crimes code. It's once again one of those situations where being a appointed public official, apparently you can no longer be held accountable for your actions. So what happened approximately 2 years ago was that 8 individuals were prosecuted up in Erie, Pennsylvania for possessing firearms in a city park in violation of an ordinance. I represented those individuals. That case went up to the Commonwealth Court, and the Commonwealth Court came down with a decision once again saying this is preempted, you can't do this, and their prosecution is unlawful. The problem was those individuals who were unlawfully prosecuted had no right to get their attorney's fees back. So the General Assembly said they've had enough of this and enacted a new bill, Act 192, that provided for attorney's fees, costs, and also for membership organizations to have standing to challenge these ordinances before someone is prosecuted under them. As a result, that bill went into effect on January 5th. Before January 5th, we sent out over 100 letters to different municipalities that had laws on the books that violated this ordinance or this regulation. There was absolutely no requirement under the new law to send out any form of notice to these organizations or municipalities, but we wanted to give them an opportunity to repeal their unlawful ordinances before the taxpayers were burdened by the lawsuits and the attorney's fees and damages that are now provided for. At this point, I would say over 60 municipalities that we've contacted have taken corrective action and have repealed their illegal ordinances. However, there are a number of cities that have not, namely the city of Philadelphia, city of Lancaster, the city of Pittsburgh, and also the city we are currently in, the city of Harrisburg. We have filed suit against the city of Harrisburg on behalf of Firearm Owners Against Crime and several individual plaintiffs because of Mayor Papenfuse's refusal to repeal these ordinances. Beyond even refusing to repeal them, they have actually boasted between Mayor Papenfuse and the police chief of Harrisburg about their prosecution under these ordinances. And let's be clear here, there are a number of state laws that could be prosecuted where someone violates any type of issue that comes under these ordinances. And those are generally graded as misdemeanor and felonies. If a misdemeanor or felony is not going to dissuade a criminal from committing a crime, a summary ordinance is going to have no effect. So that's why we believe these ordinances have absolutely no applicability. They do nothing for public safety. And more importantly, they're in violation of our crimes code. So we did file suit against the city of Harrisburg, and we're waiting on our court date now as we stand here today.
This is why, folks, I keep telling you that the gunfight is the biggest gunfights are happening at the state level, and it's not only in Pennsylvania, but I happen to be in PA and happen to run into Joshua here, and that's fantastic. Is there anything else big coming up in Pennsylvania you feel we should be aware of?
A couple things. One, somewhat related to the preemption, most people aren't aware that we also preempt any Commonwealth agency from regulating firearms in any way inconsistent with our Uniform Firearms Act. Several months back, I was actually able to get our Attorney General, Kathleen Kane, to issue a determination that the gaming board's regulation that one cannot have a firearm in a casino is actually unlawful under that preemption section. Currently, Department of Labor and Industry has regulations, as well as the PASSHE and the Department of State. We have submitted letters to them utilizing Attorney General Kathleen Kane's determination that Commonwealth agencies may not regulate in any manner inconsistent with the Uniform Firearms Act, and we are awaiting responses from them. Unfortunately, those letters were submitted about 6 months ago. The Commonwealth has been very slow in responding, and Representative David Maloney from my district has actually started inquiring as to why it's taking them so long. Their response has been, well, we need our attorneys to look over this issue, even though the statutory language is a sentence long and we already have the determination from Attorney General Kathleen Kane. So that also we're going to see what's going to transpire in the near future. Also, I think we're going to see a number of federal actions filed in this year and the upcoming years regarding misdemeanor prohibition crimes that result in a disability at the federal level. Most people don't realize, generally speaking, a second DUI here in the Commonwealth is going to prohibit that person federally from ever being able to possess a firearm, and no one needs to be injured. There doesn't need to be any property damage. Also, people are generally unaware that theft crimes, just as little as $200, although not money you'd find in the street, also not grand larceny, will prohibit someone from ever being able to own a firearm. So I believe we're going to see challenges to those federal restrictions and whether they are sustainable under the Second Amendment.
I have to admit, the fact that you got anything through the office of Attorney General Kathleen Kane is somewhat impressive. Well, Joshua, thank you so much again for all this information. It's fantastic. You're a wonderful guest. I'd love to have you on the show sometime, so we'll have to exchange information and talk again.
Absolutely, Krystal. I'd absolutely love it.
All right. Thank you so much.